Present, Your Honor. I appear together with Mr. Gachoka. Present, Your Honor. And that this matter is coming up for arguments as regards pay. From the onset, the Republic opposes vehemently the release of the accused person on bail. Article 49(1)H. Section 123, capital A of the Criminal Procedure Code, that bail is a constitutional right. We easily concede to that argument when they make it, that the right to bail is protected under Article 49(1). However, the same Article 49(1)H allows for the limitation of the right to bail to the extent, therefore, that the right to bail is not absolute. You know, that limitation of the right to bail under Article 49(1)H is in line with Article 24 of the Constitution on the limitation of constitutional rights. And therefore, that it is our argument that denying the accused person before you bail would meet the threshold under Article 24 for limiting the right to liberty and the right to security of the person in an open and democratic society as is Kenya. The second argument that the defense is most likely going to raise is that there is a presumption of innocence. Again, we easily concede that every accused person has, under Article 50, sub-Article 2A, the right to be presumed innocent, but that superior courts of this land, including in Abolfati versus Republic, a Supreme Court decision, has held that a denial of bail is not a violation of the right to fair trial and the right to be presumed innocent. So that this court, we pray, is not persuaded that if we persuade you, we have raised compelling reasons, and this court denies the accused person bail, the court will not be going contra the presumption of innocence. Your Honor, Section 123A of the Criminal Procedure Code, Cap 75, Laws of Kenya, together with paragraphs 4.9A to L of the Judiciary Bail and Bond Policy Guidelines, guide this court on what compelling reasons are. Again, the superior courts have held that the lists provided in those two provisions of the law and the guidelines are not exhaustive. Your outside the affidavit, which will be taken through shortly, it is a matter of public notoriety that the complainant in the case before you is a law enforcement officer. You're most likely going to be persuaded as to the conduct, behavior, or rather misbehavior, or alleged rogueness of the National Police Service in Kenya. Whether or not the court believes that, it is our argument that a person that has the temerity to attack a law enforcement officer, and law enforcement officers are not limited to police officers, include the prosecutors, including the ones speaking to you, and the judicial officer taking notes before this court this afternoon.
When the affidavit has been served on the accused respondent, and the matter before you commenced a report being made at Kasarani. Number 2 of that unit report. You know, at the time that report was made, the accused respondent was still at large. And he was only arrested on the 3rd. Your Honor, if you release the respondent on bail or bond, the state is apprehensive that he will flee from this courtroom and he will never be in court to face his accusers. Your Honor, that ground is captured in paragraph 8A of the affidavit. And Your Honor, taking you back to that video that is circulating on social media, which I've asked the court to invoke section 60 of the Evidence Act due to its notoriety, you will see that members of the public were in pursuit of the accused respondent. Not the complainant, but ordinary Kenyans, Your Honor. And we submit, Your Honor, that is a compelling reason showing that there is hostility towards the accused person from the public, which puts his life in danger, Your Honor. Thus, Your Honor, we are saying that the court should deny him bond to safeguard him from any person who may feel so aggrieved by the acts of those that day that they may want to avenge. Your Honor, that ground is captured in paragraph number 8C, B and C of the affidavit reborn by Presidious Patronage. Moving on to the next ground in which the state is seeking to have the respondent accused denied bond is that there is a likelihood that he will interfere with witnesses. Your Honor, will still be asking the court to invoke section 60 of the Evidence Act and take judicial notice social media posting which is doing rounds indicating that the complainant herein has been approached to drop these charges.
The battery of police communication gadget and a mobile phone. The import of a police communication gadget in the possession of an accused person is a grave national security issue. That is the person you are being told to release. And I urge the court to take judicial notice that police communication gadgets are a serious tool for the preserve of the police.
Again, Your Honor, we object to that line of argument.
Could I get a checklist what they want me to talk? That before the court renders itself on the suitability of the accused being granted bail or denied bail, court orders for a pre-bail report to bring to the attention of the court the actual circumstances within the community, within the family, so that the court will arrive at a fair and just decision to deny or to grant. But on behalf of the family, on behalf of the complainant, we completely object for the accused to be released on bail. Prayer is that he be allowed to testify. If the court will be inclined to grant bail or bond after he has testified, given his version before this court. That's all.
Issue of time is an issue. Your Honor, first of all, we submitted extensively yesterday and took a lot of your time. In persuading you, Your Honor, to reasonable bond, terms or cash bail options. So, Your Honor, I would want to adopt, and that is the position of the defense, the submissions we made yesterday, mutatis mutandis, as our submissions today. But over and above that, Your Honor, based on the affidavit that has been brought before you, Your Honor, we will demonstrate that in this affidavit, Your Honor, it is the prosecution itself, as opposed to the victim or the investigating officer, that is perpetrating these particular reasons that have been given. Your Your Honor, the prosecution, and it has made it a habit, I wish J.V. Witty was here, they have made it a habit to actually yell more than, they yell the loudest, yet they're outside there taking Coca-Cola.
We don't object.
Yes. Your Honor, if you look at the reasons that have been given, first of all, in terms of the legal parameters, Your Honor, we are all in agreement that bond is a constitutional right. We do not need to regurgitate that. The only thing you've been told, Your Honor, is that it indeed can be limited. And Your Honor, my brother J.V. rightly pointed you to Article 24.1. And Your Honor, the wording of Article 24.1 is very clear. It gives the fact that yes, a right can be limited, but it cannot be limited except by law, and the second qualification, which is very important, only to the extent that that limitation is reasonable and justifiable.
You've been invited to look at the status of the victim, the alleged victim, his age, his time, period of service in the police service. But that has never been a consideration while evaluating the compelling reasons under Article 49. You've been asked to deny him bail on the count of his safety. You've been told that the only place that he can be more safe is with the police. We have allegations that the police have assaulted our client. And we are the complainants.
I think that's not correction. He will be
Police, as defined by Article 244 of the Constitution, if then he is not safe with the police who have now assaulted him. My running friend Mr. Okach was asking us, where is he safe? I want to submit that safety is not determined by the status of the victim. Further, Your Honor, I want to address you on paragraph 8, clause E. The DPP states that the complainant, who is 57 years old, feels victimized on social media and requests to testify before the accused person is released. It has not been alleged that our client is responsible of those social media publications. And he has not disclosed the source of the said victimization, nor has he associated it with our client. We submit therefore, Your Honor, that there is no jurisprudential value in alleging that he needs to testify first, so that then you can consider granting our client bail. Your Honor, if the alleged victim feels victimized, my learned friend Mr. Omari knows the existence of Section 4 of the Witness Protection Act. They have not taken advantage of that provision, so that, Your Honor, if it is true that he is threatened, then they can take the necessary actions to commit him to witness protection. Your Honor, Section 4 provides, subsection 2, that without prejudice to
machinery, including tools of violence. In any event, in Republic versus Dwight Sagary and others, the High Court has this to say. For the prosecution, cogent evidence of either real or perceived interference. Your Honor, whereas counsel are supposed to be well deep into the books of law, of Mike Buvisonko with unknown Kenyans without demonstrating their relationship, concord videos to come and convene this court that there is witness interference. Refuse that invitation, Your Honor. Your Honor, of taking bribes. Do they take bribes on behalf of the nation and the people of Kenya? When the police officer kills Willie Kimani, are they killing Willie? Your Honor, the same way the police commit crimes in their personal capacity, when it is alleged that they are beaten, it is individual police officers who are beaten and not deny bond. And we gave you the authorities. Would not wish to say more regarding those authorities. That even if you released the accused person, the police force will not be willing to protect him. We wish to go on record as advocates of the accused person.
We have enjoyed impunity by prosecuting people with offenses that a three-judge bench had declared unconstitutional and not meeting constitutional threshold under Article 50 to continue charging people. And Article 25 is very clear that the right to be heard is not non-derogable.
Are we now discussing the decision?
No, I think what, let's not, I think cases, yeah, and have the advantage of looking at it. Yeah, so let's not really waste so much time on that. Yes. Okay. Yes, Mr. Bishop. Comes to a point of a ruling. So I'll reserve the ruling for Friday this week, on the 7th. Let me just finish. And then I'll also call for a pre-bail assessment report so that I can get additional information. I think it has been imputed that we're not certain on the residence, on whether the accused person is a student. I think that additional information will come through that report. So I think it's very important and critical that we have that report. So I'll seek that report to be filed tomorrow, and then I'll render my ruling at 9 a.m. on Friday, the 7th. Yes. Yes.
That's good enough. Yes, good enough. That's good enough.
We will concede Your Honor to that.
The in charge check the door. He can
inform Your Honor, I'm just asking for that please when you become a medical doctor tomorrow. It's a matter of
Yes. Yes. As what say, as what.
Yes.
You must oblige.
Most obliged.
And the last thing, Your Honor, to